a declaration coming out of civil.
No. So that again, the Samula overlooks that the 7-member bench actually contemplated perhaps both. The 7-member bench said also
but
part
to one
of
extent, I mean, to civil only they've come up with some answer.
A part of A that they say that जहाँ पे court का बताना था तो उन्होंने कहा कि civil होगा. It did not then hold that why not a conviction.
And उसमें भी problem ये है फिर तो अगर if we are so then we stuck on the very basic question कि declaration from a court of competent law क्या है?
That's right, sir.
So
that has to be answered.
So that's not answered.
Yes.
So बाकी सारी चीजें तो दूर की बात है ना कि duration
everything is based on that premise that there is a declaration by a court of law and we don't know.
So we're assuming on Samullah's argument that there is a declaration which would be between inter-parties arising out of civil jurisdiction, and then as a consequence we'll build into it that the person is not honest.
What would be the effect of that declaration
and effect we'll say
the consequence and so on, and then
I will go another way. I will say I cannot bring myself to disagree with Justice Khosa.
That was very profound.
What we have read, can I not say that? I cannot bring myself to disagree with Justice Khosa.
Court, my lord, yes.
He's a 7-member bench member. The others have not disagreed with him. They should have said, we don't agree, this is a dissent you're writing. You're not writing an opinion of the court.
So where does that leave us, Amir?
So, my lord, now I think as a first step, in my respectful submission, as a first step, my lord would have to first hold what court would it be or what courts would it be, civil or criminal, either or both, which would give this sort of declaration for the purpose of 62(1)(f)(1). What would be the procedure which will have to be adopted for the purpose of that declaration? What is the standard of proof which would be required, both, and then the locus standi?
In 𝐋𝐈𝐕𝐄, the High Court refused to interfere. High Court refused to interfere.
Actually, this
for the reason that
question.
the High Court cannot go into such.
यहाँ पर आपको अपडेट करते चलें इस हवाले से कि बुनियादी हुकूक को नज़रअंदाज क्यों कर रहे हैं। नाअहली की मुद्दत से मुतालिक केस की सुप्रीम कोर्ट में समाअत का सिलसिला जारी है।
देखिए, बात वहीं आ जाती है, इतने दिनों से हम ये सोच रहे हैं कि कैसे करें। तो आपके ख्याल में रिटर्निंग ऑफिसर समझ लेगा बात को या आम शहरी समझ लेगा?
मैं अभी आगे आता हूं।
जो खोसा साहब की बात है, मुझे तो बड़ी भारी बात लग रही है। उसमें मुझे कोई आई एम ट्राइंग टू इन माई माइंड ट्राइंग टू disagree with it, and I can't bring myself to disagree with it. He's saying you cannot give these declarations full stop. So maybe these are just rhetorical questions. They don't have an answer. I mean, there are many questions you don't have an answer for. This may be one of them.
इसकी एक interesting बात बताऊं.
However, nonetheless, Parliament has understood 62(1)(f) better than us and has formulated something. Okay, fine, good for you, Parliament. They represent the people of Pakistan. They've understood it, they've done it. Now, unless I can then say Parliament has done something wrong, the only thing Parliament says कि भाई आपके 7-member bench को हमने follow करते हुए ये काम कर दिया है. It is more in tune with the 7-member bench judgment, section 232(2) than Samula is.
That's right, sir. And मैं थोड़ा सा एक background बताऊं. My lord was originally अभी एक्सप्लेन हुआ कि सिर्फ 3 प्रोविजंस थी, A, B, C था 62 में. When the constitution was being made, certain amendments were proposed by members who belong to religious parties. I'm talking about the original constitution making, at the time of original constitution making. I'll just read out very slowly. I don't have, unfortunately, a copy of it. 2 amendments were proposed and motions were made and they were negatived, they were rejected. And if I may read out, they are quite akin to what was then inserted through revival of Constitution Order 1985 by General.
Where are you reading from? Parliamentary debates?
Parliamentary debates.
Copies दे दीजिएगा मैं.
जी copies दे दूंगा मैं. I'll just slowly read it out. And these were rejected.
What year is this?
This is, my lord, 1973. These are dated 15th of March 1973, sir. So the first amendment which was proposed was, he is conversant with the affairs of the country, which is okay. He is conversant with the affairs of the country and is not reputed for his bad character or for contravening the injunctions of Islam. This was rejected by the House. Second, if a Muslim, he is honest, and not an open violator of the dogmas of Islam and possesses the necessary knowledge of his religion. Both were rejected. And while rejecting it, the speaker said, and I would just quickly read out one paragraph from the proponent of one of these amendments and then the response given by the speaker.
Who proposed these?
My lord, these were proposed by Maulana Abdul Haq of Koda Khatak, Maulana Ghulam Ghaus Hazarvi and Maulana Mustafa Al-Azhari. So these were the three members who proposed them and the House rejected them. I just read out, these are very telling passages, what he had in mind and then how the speaker responded. And this is exactly what Justice Khosa has observed. जनाबे वाला मैंने तरमीम पेश की है कि पार्लियामेंट का जो रुकन हो उसका किरदार, उसका इखलाक, उसका तकवा, उसकी दयानतदारी, इसका मामला शनास होना, इस्लाम के बारे में उसकी बुरी शोहरत ना हो, ये खसूसियात भी लगाई जाएं। असल में इस दफा में ज़ेली तौर से बहुत सी चीजें लगाई हैं कि अरकान में इनका होना जरूरी है। एहलियत होगी तो मैं अर्ज करूं कि ये जो है यानी जो पार्लियामेंट है, पार्लियामेंट जो है वो तमाम मुल्क में बहुत ही अहम इदारा है। इस ऐवान के अरकान है, ये आइन बनाने वाले हैं, कानून बनाने वाले और मुल्क के अंदर अदल और इंसाफ कायम करने वाले इदारे के अरकान हैं। इसका जवाब सर Speaker responded and then obviously it was then later put to vote. He said, आप मुझे इसका जवाब दें कि आपने फतवा दे दिया कि इसकी शोहरत अच्छी है और वो अहल है। दूसरे कई उलमाए कराम ये फतवा देते हैं कि इसकी शोहरत अच्छी नहीं है, इसलिए ये चीज़ इसके मुंतखब करने वाले जो लोग हैं, जो वोटर हैं, उन पर छोड़ी जाती है। अगर वो समझें कि वो अहल है तो वो अहल हो सकता है। And then ultimately it was put to vote and was rejected. So,
maybe it's a guideline for the voter.
Yes.
Maybe why can't it be considered a guideline for the voter? Maybe you want, it may be not on your radar, but you should consider these points.
Some sort of inspirational standards for future.
D, E, G and precisely are that. Now what happened here? Mr. Uzair Bindari argued and he relied on paragraph 33 of Samiullah where Samiullah Baloch with respect, erroneously relies on Imtiaz Lali case of 2007 to say that pre-18th Amendment, the Supreme Court had disqualified someone for life under 62(1)(f) erroneously. Paragraph 33 refers to Imtiaz Lali, which is PLD 2007 Supreme Court 369, which was incorrect. In Imtiaz Lali case, he was disqualified on the basis of a provision which was introduced in Representations of the People's Act through Conduct of General Elections Order, which was Chief Executive's Order number 7 of 2002, on the basis that a person who was dismissed from service on the basis of misconduct or moral turpitude, full stop. They applied this provision to hold that if he could not get back into service, he could not get back into the parliament either under 63. So this is what Imtiaz Lali did. Now what did parliament do to respond? In 2010, parliament then placed timelines for G, H, I, J. Now J deals with removal from service on the basis of misconduct. They said that if he's removed on the basis of misconduct, he could come back in after 3 years. And on moral turpitude, if he's convicted and after serving the term, he can come back after 5 years. So Parliament had this judgment in mind and responded to it. What Parliament did not have in mind was that while they were creating actually a safety valve under 62(1)(f), against any arbitrary decision by a returning officer where the returning officer would ask someone XYZ or somebody would come make an allegation against somebody that he is dishonest or he owed me something and he has cheated me, etc. Parliament pegged it with a declaration by court of law. And that declaration now, as I go in greater detail what that declaration would be, this is the safety valve which the parliament had created, and unfortunately, from Ghafoor Lady to first Aladino Bhaiyo, the original Aladino Bhaiyo, to Samiullah Baloch, this court then actually turned into something which constitution makers never contemplated. Nowhere in 62 or 63 has anything been made perpetual disqualification.
But before we even get to the time frame, what I'm understanding from you is that we haven't yet crossed the first hurdle as to what kind of a declaration this is. Because under the current dispensation or legal framework, no such declaration can come about. Samiullah goes ahead and crafts a declaration, says that in case there is some civil litigation which comes up with something, then we'll, as a consequence and as an effect, connect it and make him dishonest or mean. So there is no direct mechanism or procedure available in the current legal framework to achieve such a declaration. So having said that, one option could be that the parliament goes ahead and decides the procedure, or there is a constitutional amendment, whatever might be the case. How could a court of law like us resolve this issue? Because under the current legal framework, such a declaration cannot be given. So what happens if there's a constitutional provision which becomes practically unworkable under the legal system? What do we do with that provision?
My lord, my respectful submission is, and I attend to my lord's question, but if I may just first submit, that such declaration, now if we look at the courts of civil jurisdiction and see its declaration is given by a civil court, this sort of becomes a bit inconceivable, because in what situation would that declaration come out? But if this declaration in the form of a conviction is given by a criminal court, then there are several instances where such conviction regarding the character, which is the honesty or dishonesty of a person, could be given by criminal courts and the penal code. As I just gave an example of section 403 of penal code, a person who dishonestly misappropriates somebody's property, upon conviction he is punished. Punishment is up to 2 years. 63(1)(h) is threshold doesn't get triggered because that is more than 2 years. So remaining under 3 years, under 2 years, there is a declaration of him having dishonestly misappropriating property.
It's not a civil declaration that's the problem. Right?
Civil declaration is a problem. Now, similarly, cheating, for example, is being deceitful, which is dishonesty.
Sure.
So again, it's 1 year. So वहाँ पे शायद आ सकता है, but civil declaration, as my lord has just observed, I can't think of anything.
So then what is the answer?
Now, my lord,
is the first question that since 𝐋𝐈𝐕𝐄 is pending, right?
Ji.
So unless we cross this hurdle, building a time frame and all that is a secondary question.
so that is one. That is one. It is all.
So it is best either you leave it to the parliament to do a constitutional amendment or do whatever they want to come up
So
with.
for that, you don't need the
Besides this-
constitutional amendment. Now, this is my second submission.
नहीं, मुझे एक चीज बताएं, ये हम फंस गए समीउल्लाह बलोच में, मगर जब ये खाकवानी का आपने जिक्र किया, मैंने अभी पूरा जजमेंट देख रहा हूँ समीउल्लाह बलोच का। ये कोई बहुत पुराना जजमेंट तो नहीं है, नेचुरली रेडार पे होगा, दुनिया भर के वकील इसमें पेश हुए, किसी एक ने जिक्र नहीं किया खाकवानी का। I find that very difficult। और उसमें जो सवाल उठाए गए थे, तो मतलब उसको नजरअंदाज कर दें, हम दूसरी तरफ चलते हैं, मतलब मुझे कुछ गैर मुनासिब लग रहा है।
These questions had to be addressed.
एड्रेस नहीं, कोई पुराना कोई नहीं, कोई 10 रिपोर्टेड जजमेंट है, PLD में लिखा हुआ है उसको, तो वो पूरे जजमेंट में उसका तस्करा ही नहीं, और हम फंसे हुए समीउल्लाह बलोच में, हम खाकवानी पे क्यों ना जाएं?
बिल्कुल जाना पड़ेगा, और जाना पड़ेगा, जरूरी है।
नहीं, मगर नहीं, पर आप देखिए, जो चीज हमें नहीं समझ आती है, अब सपोज एक मैं नया टर्म इस्तेमाल कर देता हूं, मैं कल को आइन बदल देता हूं, उसमें लिख देता हूं पार्लियामेंटेरियंस मस्ट बी इंटेलिजेंट। ठीक है, फेयर इनफ। कौन डिटरमिन करेगा? कोर्ट ऑफ लॉ करेगी? कर ही नहीं सकती है। मैं ये आपको कह रहा हूं, मेरे हिसाब से ये कोई चीज भी कोई कोर्ट नहीं डिटरमिन कर सकती, बिकॉज ये उनके जुमरे में आता ही नहीं है। कोर्ट डील विद नॉट फिलोसॉफिकल कॉन्सेप्ट्स, कोर्ट डील विद टेंजिबल थिंग्स। हाउ कैन यू डिटरमिन समवन्स ऑनेस्टी? एंड इट्स अ वेरिएबल। अ पर्सन में बी ऑनेस्ट टुडे, डिसऑनेस्ट टुमारो, ऑनेस्ट टुडे, डिसऑनेस्ट टुमारो। आई डोंट नो, पीपल कीप चेंजिंग। So these are not the kind of determinative things. Probably the 18th Amendment brought in the word through a court of law to virtually kill it off, but they didn't realize they probably created more of a mess than the original wording. I don't know, that maybe have been the intent. अब पार्लियामेंट ने काम कर लिया है, मुझे नहीं समझ आया, अगर उन्हें कर लिया है, चलें, गुड लक टू देम, उन्हें का 5 साल, फाइन, why can't we live with it? I mean, जब 7 मेंबर जजेस कह रहे हैं कि ये सवाल या तो उनको अटेंड करें, आप इग्नोर नहीं कर सकते हैं कि जी आप मैं दूसरा जजमेंट लिख दूं, मैं उसको इग्नोर कर लूं, जब बिल्कुल वही चीजें हैं, वही इशू है, वही इलेक्शंस की बातें आ रही हैं और आप उस तरफ चल पड़े। सॉरी, मेरे हिसाब से आई एम रीडिंग मोर एंड मोर ऑफ जस्टिस खोसरा's जजमेंट एंड आई फाइंड दैट द आंसर यू कैन नॉट answer these questions. Not every question is answered. Some are answered in the hereafter. Some are answered, okay, if I take a vote today, no disrespect to you, is Mansoor Awan an intelligent person? Maybe some will say no, most will say yes, I can assume. So these are opinions. I mean, you may hold a thing on myself, they'll have an opinion on me. But it's not something that I can get a declaration from a court of law. Declaration of court of law means that you cannot have a second opinion on the matter. End. Khatam.
No, but having said that, the legislation that's come about is also ignored Ishaq Hakwani. Because where is the answer to what kind of a declaration should it be? It just answers the time frame. That's a secondary question. The legislation should have thought that there's a Ishaq Hakwani raising all these questions. They should have explained where do we get such a declaration? How do we do it? What's the procedure as it mentions? But all these things are missing. So, I mean, we can't even get to the second question if we want to take it head on, unless we can come up with some sort of a sandwich definition of a
जवाब में मैं ये कह सकता हूँ, कल शायद पार्लियामान करने दें उनको अपना काम.
Fair enough. So I'm just saying that even if we were not to address this head on and come up with some sort of a sandwiched answer to a declaratory order or whatever declaration, it will lead to problems for the future again.
Now, at the end of the day, we have to establish one thing once and for all. You believe not just in election. कराना ही तो एक प्रोसेस है. Will of the people is reflected. The will of democracy means that the will of the people is reflected. The will of the people, whether they bring a constitutional amendment, whether they bring a legislative thing, it is the will of the people, whichever way you look at it. The next lot of parliamentarians will come, they will make a law saying this will be a lifetime ban, then we can consider its constitutionality. Our role should only be not to fill in the constitutional gaps if there are any. Our role should only be to examine legislation. Does it accord with the Constitution? And I would go back, I may not even agree with Parliament, but I will keep quiet about it. As a voter, I may do something else. So why are we getting bogged down in this business? Why are we doing this job?
So if I may just address both of these questions, observation and questions. The declaration under 62(1)(f) has to be by a court of law, acting under a law or several laws. The law has to provide for which court will have to give that declaration, and then of course the entire process, including who will have the locus standi and the standard of proof which would be required for such declarations. Now what section 232 does is, and stops midway, is that it says that the procedure, manner and duration of qualification and disqualifications will be such as is provided under 62 and 63, and where there is no procedure, manner provided, it will be such as is
The legislature
provided.
is actually not addressing that.
Now this declaration question has been left
it is
open
not
and
the answer
it
of
has not
your
been
first-
addressed.
It's not addressing the
It
question.
is not.
It is not
Now
the
what
answer of
only
your
thing
first
what it does is, it says that whenever that declaration comes out, the effect of that declaration would be for 5 years.
That's it.
That's the only thing it does.
How that will come out?
Yes.
Will be come out.
So
I wish the wording was that the declaration is for that period.
Yeah, I
It doesn't say
appreciate-
that, but that's a separate
read-
issue.
read out-
But I
read
think
out
that's a
kar sakte
secondary
hain.
issue. The main issue is, what do we do? I mean, we can't even say that this legislation has come up with an answer either.
So
Declaration subject to due process of law, ये लिखा हुआ है.
जी, वो due process of law, and then it says that the disqualification shall not exceed 5 years from the date of declaration.
I'll tell you what Parliament did.
Parliament has
उन्होंने कहा हम इसको बस छोड़ो, इस बहस में पढ़ो नहीं, 5 साल कर दो, खत्म. That's in a nutshell what Parliament did. अब we can't tell Parliament to craft a law this way because in my mind this is the best way to proceed. This is their job. Our job is another job. Is it unconstitutional?
My lord.
The one proposition was put forward, do not touch upon 232. You may need to touch upon 232 at another juncture. I'm just speaking aloud for myself, I tend to agree with that. Nobody has challenged it. We assume it's okay till someone comes and attacks it. Maybe it's a very good attack. I don't know. Maybe they say, "Ki 5 saal bhi kyun?" I don't know. Let's leave all these things. The fact is someone has applied their mind and made a law. And that law specifically mentions all judgments of any courts. So that law has shown us respect in the sense that they have just, like my Honorable Justice Afridi has said, it was not lifetime thing. So they have kind of brought it about by this legislation 5 years over. अब ये बहस किसी और दिन के लिए रखेंगे हम, अगर जरूरत पड़ेगी या नहीं.
And then also this important question.
What do we say about declaration?
Now,
it seems that at the time of Samiullah, the court was pushed to do the work of the parliament. And now again it is being presumed that we will do the work of the parliament.
And court has not said for the permanent disqualification, it is only as long as the declaration will remain in field. Again, I will put you this question, why the section 232 cannot fix the period of that declaration?
it can, sir. Because, and I respond
Then
to
there
this.
is no
It can, sir,
inconsistency between the Samiullah and the Act.
Because 62(1)(f) has two components. One is this cause of this disqualification. This cause of this disqualification, and cause of disqualification is a declaration by court of law. So this declaration or this cause is rooted in law, resulting in a declaration by a court of law, and the consequence is constitutional, which is a person stands disqualified. Now what the Parliament has done is, it has limited and placed a certain limitation upon the cause, the declaration. The consequence stays where it is. Now the
Declaration means the disqualification will remain in field for 5 years.
in this case,
according to
5 years.
Section 232.
Yes. Yes. And if, for example, if there was no 232(2) and Samiullah is overturned, then the disqualification would only be for that election. For that particular election, which is declared either void or a person is de-seated based on that declaration. He would become eligible after if Samiullah is overturned. But this law then places a certain limitation. It gives longevity to that declaration of 5 years, which, to my mind, my lord, Parliament in its wisdom thought that if under 63(1)(h) we had provided 5 years at that time, then because this declaration is coming under a law and for that constitutional amendment is not required, it is only perhaps fair that we give a cooling off period of 5 years.
So what is the procedure to deal disqualification under section 60, under Article 63?
Sir, now when a declaration is come and if the question arises, a person has become disqualified, then chairman or the speaker under clause 2, the question
That is
goes to them and
provided
then they refer to election commission.
Under sub-article 2 and sub-article 3
That's
of
right, sir.
Article
That's right,
63.
sir. That's right, sir.
Mr. Ji, Article 62(1)(f) says court of law. Whether criminal court is not court of law, and
Yes.
why in Samiullah Baloch it was restricted only to civil court.
जी जी नहीं हो सकता मेरा ख्याल है अब पार्लियामेंट उसका क्या फैसला करती है वो पार्लियामेंट ने उसका एड्रेस करना होगा बट और अनलेस माय लॉर्ड्स आर माइंडेड टू होल्ड बट इन माय रिस्पेक्टफुल सबमिशन इट कुड बी बोथ इट कुड बी अ डिक्लेरेशन बाय अ सिविल कोर्ट और अ कन्विक्शन बाय अ क्रिमिनल कोर्ट व्हिच माइट एंटेल दीस कॉन्सिक्वेंसेस बट दैट इज अगेन
It is assumed if it is of the opinion that member has become
के
disqualified.
तयन से मुतालिक केस की बराह रास्त नशर समात इस वक्त जारी है.
Declaration, no, despite that declaration, the election commission can undo that declaration.
No, the election commission, for example, disregards that declaration.
Yes.
Then a person can come before your lordships or in the High Court under 199 Coveronto and say that here is a declaration.
Validity of the declaration issued by court of law.
Yes, so declaration is not the validity which can be questioned by the election commission or by the speaker or a chairman in that case. If they come to the conclusion that this declaration is actually not 62(1)(f) declaration, this is perhaps for an offence or something which is not
So,
covered
Mr.
in
Mansoor, you've
62(1)(f).
landed us in a bit of a more problem here. So the question was earlier that we were going along with whatever semblance of a declaration was given by Samiullah or civil litigation, original civil litigation. We thought we'll take that declaration and then play around with the duration period. Here the question is that there is no declaration and that's not really a declaration, and Isaaqa Kwani raises that question. Nobody has addressed it head on as to what could be such a declaration, and that declaration probably requires some serious thought from the parliament. So where does that leave us now?
So, my lord, what that leaves to your leaves you, the declaration so far given, people might come in due course to the courts that these declarations were not declarations by a court of law. I dare not.
I put myself in the position of whatever that court is for the time being. I would say I cannot give this declaration. Bye. Take away your suit. Take away your plane. Take away whatever you want to do. I cannot do this. I mean, I cannot go into your hearts and determine what sort of human being you are.
That's right.
So taking that question further, what do we do with the constitutional provision now?
So what happened here?
Say it's unworkable, wait till the parliament decides.
My friend,
इसका भी जवाब आसान जवाब है, बहुत आसान जवाब है। इसका बहुत आसान जवाब है, जो लोग कॉन्स्टिट्यूशन बनाने के माहिरीन थे, उनमें ज्यादा अकल और दानिश थी, उन्होंने 73 का आइन बना दिया। और उन्होंने एक साहब टहलते हुए आए, उन्होंने कहा हो कहीं ये लोग सर ना खड़ा कर लें, तो ऐसी चीजें डाल दो इसमें कि हर कोई जो मेरी मर्जी हो मैं उसको डिस्क्वालीफाई कर सकूं। अभी इस बात को हम क्यों नहीं कह रहे हैं, इसको बात का एतराफ क्यों नहीं कर रहे हैं? तो समीउल्लाह बलोच स्पेसिफिकली मेंशंस दैट इट वाज इनकॉर्पोरेटेड बाय इन द ड्यूरिंग मिलिट्री टेकओवर।
बिल्कुल बिल्कुल।
So I mean
the revival of
I don't know why we so
1985, but 18th Amendment में Parliament had the
of grammar and English and we are forgetting the overall picture.
18th Amendment. The problem is that
18th Amendment भी वही मसला है ना कि इधर आपने देख लिया क्या हालत हुई थी पाकिस्तान में, वो भी हम क्यों नहीं बात कर रहे हैं उस बात की? जरा सी उन्होंने लैंग्वेज बदल दी तो उन्होंने पता नहीं पूरा पाकिस्तान came to stand still. We must realize that there are issues which are exploited for personal ulterior motives.
My lord,
gain certain political advantages. Okay? Now, once we are not a court of law that we should shy, we are not that we should shy away. We are a court of law, upholding the Constitution of Pakistan. Constitution does not, rightly or wrongly, does not provide a time period. Why should I fill in what the Constitution has intentionally left, even if I accept it at par with every other constitutional provision, something brought in by a military dictator? भाई उन्होंने नहीं किया, वो जाने मैं क्यों काम उनका करूं? नहीं, आपको जरूरी करना है, क्यों? भाई देखें, absence is also a decision. If I don't decide to do something, I'm deciding something. Parliament has elected to leave it aside. We also leave it aside.
My lord,
अगर वो कल कोई कानून साजी करेंगे हम देख लेंगे उसको.
Mubashir Hassan case में my friend Ahmed Qayyum read out paragraph 115 from Mubashir Hassan, where the full court held that 62 is not a self-executory provision. 62(1)(f) is not a self-executory provision. And they were
judges थे?
Sir, it was a full court. It was, I believe, 15 or 17. Full court, thi, sir.
What context was that?
So they were looking at examining 62(1)(f) because it was NRO which was under challenge. NRO under challenge था, तो उसको वो देख रहे थे, and उसमें 62 को उन्होंने examine किया 62(1)(f) को, and they went on to hold that it is not a self-executory provision, and by that, I think it doesn't explain it in that detail, but perhaps the rationale behind that was that because there is a declaration by a court of law which is required, then there is
98.
a law or several laws must also provide some mechanism how that declaration is to then come out.
I mean,
Now, what has happened here is that 232(2) provides a time frame for the longevity of that declaration, but it does not then address the 4 questions which were left open
उससे
by.
आपसे वही पूछ, I mean, this
तो
constitutional
आप
silence
उसको
has
ये कर
really got
सकते
us.
नहीं सर, अब आप उसका ये कर सकते हैं. Options here. Either you leave it to the parliament.
Yeah.
Elections are around the corner. Leave it to the
Till
parliament.
then, what is the status of this provision?
So this provision is, as the Supreme Court held, is not a self-executory provision. It requires making a law.
Till such-
The law has to be made, and that is for the parliament to do.
नहीं, अगर ये इन्होंने वर्डिंग लिखी है स्पेसिफिकली, मैं मुबशिर हसन देख रहा हूँ. मुबशिर हसन में जरा गिनते हैं 1 2 3 4 5 6 7 8 9 10 11 12 13
पेज पढ़ रहे थे आप,
14 15
पेज कौन सा पढ़-
17.
Paragraph 115.
हाँ, 115 में 17 जजेस हैं, यानी कि फुल कोर्ट.
जी, 114.
It is true that, अच्छा, the provisions of Article 62 of the Constitution cannot be pressed into service because it is a provision of Constitution which is not self-executory. तो ये तो फिर बुनियादी उड़ा देता है बाकी जजमेंट्स की. इससे अगर मैं डिसएग्री करना चाहूं, मैं कर ही नहीं सकता हूं, क्योंकि अगर हम सारे जजेस भी बैठ जाएं फिर भी हम 17 नहीं
Did
बनेंगे.
Ishaq Akwani look at this?
Ishaq Akwani did not, I think.
नहीं तो Ishaq ने probably realized
Ishaq Akwani was
ये
perhaps.
अच्छे सवाल हैं मगर इनका जवाब नहीं मिल सकता.
But Ishaq Akwani would have, if it had gone on to examine it, I think this question would have come. Or that because this provision actually requires making of a law by the parliament to give effect to this.
There is a reference to a judgment, Muhammad Afzal versus.
This is Raja Muhammad Afzal versus Muhammad Altaf Hussain, sir.
ये तो फिर
1986, 1736, it said that
फाइंडिंग तो आ
that
गई.
judgment said that it's a declaration.
I think this has clarified something.
Mubashir Hassan sir puts an end to it.
Is a definite finding.
It's an inert, innate provision.
Yeah. So as D, E and G, for example, now they operate on their own, perhaps more so an appeal to the electorate.
Yeah, then they
F
all
also is an appeal to the
after
electorate.
this finding, they just join the family of the rest. You see, D, E, and G.
G.
They all become nice inspirational guidelines that we must have a parliament like this. And
Yeah.
that's it.
That's it. And if
That's
we have an appropriate law providing for how that declaration would have to come forth, it is in a way.
Which is any judgment. See that? Huh?
Yes. But what Mubashir Hassan, what 232(2) does is, it does provide for the duration part. It does not provide for the procedure and manner part.
इसमें
In Sabina Baluch, Mubashir Hassan was mentioned or no?
No, I don't imagine, sir. I did not come across more.
कि मुबशिर हसन में कहा है कि विच इज नॉट सेल्फ एग्जीक्यूटरी, ठीक है. बट अब समीउल्लाह में अगर हम देखते हैं, समीउल्लाह में उन्होंने कहा कि सिविल कोर्ट का जजमेंट होना चाहिए, तो उन्होंने भी सेल्फ एग्जीक्यूटरी तो नहीं कहा है, उन्होंने भी कहा है कि जजमेंट होना चाहिए सिविल कोर्ट का. देयर मस्ट बी सम डिक्लेरेशन बाय द सिविल कोर्ट.
ये उन्होंने कहा, और ये उन्होंने जरूर कहा, और ये अल्ताफ ये उन्होंने जरूर कहा कि जी डिक्लेरेशन होना चाहिए. एंड परहैप्स ये
नहीं, पर आप ये पढ़े ना, जरा वापस आइए.
एक reading हो सकती है.
114 पे आए, पैराग्राफ पेज 423 ऑफ मुबशिर.
जी, उसकी एक रीडिंग ये हो सकती है.
नहीं, वो पढ़ेगा. इट इज
सुप्रीम
ट्रू.
कोर्ट में सियासतदानों की ताहयात नहली की मुद्दत के तयन से मुतालिक केस की बराह रास्त समाअत जारी है. समाअत के दौरान चीफ जस्टिस ने रिमार्क्स दिए कि इस केस में इनफरादी लोगों के मुकदमात नहीं सुनेंगे. हो सकता है तब तक हमारा इस केस में ऑर्डर भी आ चुका हो. चीफ जस्टिस काजी पाइसीसा की सरबराही में 7 रुकनी बेंच इस वक्त समाअत कर रहा है. अदालती कार्रवाई इस वक्त बराह रास्त आप हमारी टेलीविजन स्क्रीन पर देख रहे हैं. यहाँ पर आपको खबर दें कि इंतखाबात मुलतवी करने की करारदाद सेनेट में पेश कर दी गई है। आपको अपडेट कर रहे हैं इस हवाले से कि सेनेट का इजलास अमेरिका के सुबह से जारी है और इंतखाबात मुलतवी करने की जो करारदाद है वो सेनेट में पेश कर दी गई है। आपको अपडेट कर रहे हैं इस हवाले से कि करारदाद जो है वो इंतखाबात के हवाले से मुलतवी करने की सेनेट में पेश कर दी गई है। आपको अपडेट कर रहे हैं इस हवाले से कि इंतखाबात मुलतवी करने की करारदाद सेनेट में पेश कर दी गई है। करारदाद खैबर पख्तूनख्वा से मुंतखब आजाद सेनेटर दिलावर खान ने पेश की है। मुल्क के बाज़ इलाकों में शदीद सर्दी का मौसम है, ऐसा कहना है सेनेटर दिलावर खान का मौक़िफ़ सामने आया है। उन्होंने कहा कि सियासी जमातों ने अपनी तहफ़्फ़ुज़ात का इजहार किया है। बाज़ सियासी जमातों के रहनुमाओं को सिक्योरिटी थ्रेट्स भी हैं। इंतखाबात मुलतवी करने की करारदाद जो है वो सेनेट में पेश कर दी गई है और दिलावर खान ने जो है वो सेनेट के अंदर ये करारदाद पेश की है। उन्होंने कहना है कि इंटेलिजेंस एजेंसीज ने रैलियों पर हमलों का सिक्योरिटी अलर्ट भी जारी किया है और कोरोना के केस आना भी शुरू हो गए हैं। 8 फरवरी को इंतखाबात मुलतवी होने चाहिए। आपको अपडेट कर रहे हैं इस हवाले से कि इंतखाबात मुलतवी करने की जो करारदाद है वो सेनेट में पेश कर दी गई है। करारदाद खैबर पख्तूनख्वा से मुंतखब आजाद सेनेटर दिलावर खान ने पेश की। मज़ीद खबरों और अपडेट्स के लिए आप देखते रहिए डॉन न्यूज़।
नया सनसिल्क थिक एंड लॉन्ग, इसमें है योगर्ट प्रोटीन और केराटिन का सुपर मिक्स, जिससे बाल दिखे 2 गुना ज्यादा घने और मुमकिन करे हर हेयर स्टाइल। इस शादी सीजन जब बाल हो थिक, कोई भी स्टाइल करो पिक।
अब डेटा मिले एक्सट्रीम विद मंथली सुप्रीम। लगाएं और पाएं पूरे 20 GB डेटा और इसके साथ 500 अदर नेटवर्क मिनट्स और 5000 जोंग मिनट्स और SMS सिर्फ 999 रुपए के लोड में। अभी स्टार 3030 हैश मिलाएं। जोंग 4G।
जिंदगी हमें खाना पकाने की इंस्ट्रक्शंस तो दे सकती है, पर मोहताजी से लड़ने की नहीं। और वो अब्बू ही क्या जो अपनी बेटी को किसी का मोहताज होना सिखाए। अपनी बेटी को जिंदगी जीना सिखाओ, शान से शान, खुशियां चख लो।
एक माँ ही बनाती है बेटी को सर से मजबूत, जड़ से मजबूत। लाइफ बॉय शैम्पू का मिल्क प्रोटीन और एलोवेरा फॉर्मूला बनाए इसके बालों को मजबूत। लाइफ बॉय शैम्पू, तुम मजबूत हो।
MNU perfume body sprays for men and women.
Never let me go. क्या है डव का नेचुरल ड्राई टेस्ट? स्टाइलिंग के बाद तो सबके बाल अच्छे लगते हैं, पर नेचुरली ड्राई होकर
उलझे हुए, इतने बेजान, बहुत सूखे।
ये सब डैमेज की निशानी है। इन्होंने ट्राई किया डव इंटेंस रिपेयर। इसमें है 1/4 मॉइस्चराइजिंग मिल्क और न्यूट्री सीरम, जो डैमेज रिपेयर पहले वॉश से शुरू करे।
इतने स्मूथ, काफी सॉफ्ट लग रहे हैं। मुझे यकीन नहीं आ रहा है ये मेरे बाल हैं। I love it.
डव इंटेंस रिपेयर, डैमेज रिपेयर शुरू पहले वॉश से।
पाकिस्तान जितने खाने बनाता है, नया ब्राइट उतने ही दाग मिटाता है।
क्योंकि नए ब्राइट का बेस्ट एवर फॉर्मूला गहराई से दाग निकाले।
क्या आपको चाहिए शाइनी बाल? सनसिल्क ब्लैक शाइन में है 5 नेचुरल ऑयल्स के साथ विटामिन ई का सुपर मिक्स, जो दे आपके बालों को अप टू 24 आवर्स शाइन। अब बाल करें शाइन ऑल द टाइम विद सनसिल्क ब्लैक शाइन।
सर्दियों में नज़ला और जुकाम बनते हैं कई बीमारियों का सबब। डेटॉल सोप के रोजाना इस्तेमाल से सर्दियों में बच्चों को बीमारी से शील्ड करना है आसान। इसका जर्म डिफेंस प्रोटेक्ट करे 100 बीमारी फैलाने वाले जरासीम से और दे यकीनी हिफाजत।
एक माँ ही बनाती है बेटी को सर से मजबूत, जड़ से मजबूत। लाइफ बॉय शैम्पू का मिल्क प्रोटीन और एलोवेरा फॉर्मूला बनाए इसके बालों को मजबूत। लाइफ बॉय शैम्पू, तुम मजबूत हो।
पोर्शंस प्लान करना तो कोई तुमसे सीखे।
आज की मॉम्स जानती है कि पोर्शंस में ही किफायत है, इसीलिए डेली ब्रेकफास्ट ऑल पर्स 1.5 पाव से प्लान करती है।
ग्लास भर गजायत, बोल भर खुशी, 1.5 पाव से 2 कप चाय भी बनी। पूरा करे ब्रेकफास्ट का वादा, 1.5 पाव भाई हर माँ को ज्यादा। हैप्पी सुबह
ऑल पर्स की वही प्योर गुडनेस अब 1.5 पाव बचत पैक में।
हैप्पी सुबह।
नया नया सनसिल्क थिक एंड लॉन्ग, इसमें है योगर्ट प्रोटीन और केराटिन का सुपर मिक्स, जिससे बाल दिखे 2 गुना ज्यादा घने और मुमकिन करे हर हेयर स्टाइल।
इस शादी सीजन जब बाल हो थिक, कोई भी स्टाइल करो पिक।
पहली बार विटामिन सी और ग्लिसरीन के साथ नया लक्स, जो जिल्द को निखारे, नमी दे और दे चांद सा रोशन चेहरा।
लक्स फेस ऑफ द ईयर माया अली।
थैंक यू लक्स, पर ये अवार्ड सिर्फ मेरा नहीं, ये है इन सभी खूबसूरत चेहरों का जिनकी रोशनी से दुनिया रोशन है।
लक्स, हमारा बेस्ट सोप, दे चांद सा रोशन चेहरा।
चाहे कुछ भी हो जाए, बाल रहे फिंगर कोम्ब रेडी विद पाम ऑलिव नेचुरल शैम्पू। बालों को बनाए इतना स्मूथ और मैनेज